Uh, Good evening, guys, and welcome to another episode. Yeah, and I say good evening. Good evening, guys. Welcome to another episode of Diaco Talks Law. On today's episode, we are going to continue on, what I was talking about in last class. You know that we had this lecture in last class where I talked about definition of exclusion clause, and I also talked about standard form contracts, right? In my last class, right? Yes. And I told you that in this class, we are going to have two parts. So after this, there's going to be another class, but on the same subject matter of rules guiding exclusion clause under signed document. Rules guiding exclusion clause under signed document. Can you check if the sound is working properly?
On edge.
What is it?
On edge.
Oh, okay. I would have said something about glue, but that is bad publicity. Okay, I think it's working properly. Yeah, sorry about that. I just wanted to confirm once more if the sound was okay before I continue, so that it doesn't then become a futile effort at the end of the day. So yes, as I was saying, so today we'll be talking about rules guiding unsigned documents, and then we are going to split the class into two classes, right? Yes, and for those who are coming to my channel for the first time, standing before you is Olayeni Diekolola Daniels, popularly known as Dieko Spectre, and welcome to another episode of Dieko Talks Law. Oh my god, I'm so sorry. There's someone behind the scene who is giving a very funny reaction to me pronouncing my name. My name is one of the most beautiful names, as you would know. So she's just, her name is Peace. Her name is Peace, so you can see why she's against my beautiful name. But that's that for that. Let's go straight to the class that we have today. So yes, we are talking about unsigned documents today, right? And how they relate to exclusion clauses, right? Unsigned documents and how they relate to exclusion clauses. So the rule, let's go straight to the notes. The rule for determining whether the injured party is bound by an exclusion term in a document not signed by him was first propounded comprehensively. If you are in the exam hall and you see a problem question or an essay question and they tell you to talk about, you can see that the substance of the question is to talk about unsigned documents and exclusion clauses. How exclusion clauses operate where it is written in a document, but that document is not the one signed by the party. So it's just written in any document relating to the organization that seeks to exclude itself from liability. But the other party, did not sign that document. If you see that thing in exam, the first case, if I'm the lecturer, the first case that I want to see after you finish stating the rule is this case of Parker versus Southeastern Railway Council. And in every exclusion clause question, especially when it's on unsigned, there are two categories of exclusion clauses: signed documents and unsigned documents. So when you're talking about unsigned documents, except the category that you were at specifically has nothing to do with unsigned documents, that's when you don't cite these cases. Has nothing to do with unsigned documents. It has everything to do with signed documents. That's when you don't write this particular case. But if it is unsigned document, and I don't see this case personally, myself, if I were lecturer marking, I'll first -2 for not citing the case at all, because you are writing exclusion clause and you don't have the case. So to say the case again, Parker, Parker versus Southeastern, Southeastern Railway Company. So now what happened in this case? I want you guys to flow with me. Now, In that case, the plaintiff deposited a bag in a cloakroom at the defendant's railway station, paid the clerk $2, and received a paper ticket on which was printed a number and a date and notices as to when the offices when the office would be open, and the words "see back." On the other side, several clauses were printed, including the company will not be liable for any package exceeding the value of £10. When the plaintiff returned to claim the bag, it could not be found. He brought a claim for 24. Don't forget that the exclusion says if it's more than £10, nothing. Then he brought a claim for £24.10 for its loss. And the defendants rely on the clause limiting their liability to just £10. So don't forget that when I was talking in my last class, I told you that when you're talking about exclusion clause, it must have been expressly stated. Is it expressly stated here? Yes. The second thing is that we are talking about the fact that there must have been an exclusion of liability. The question then becomes, to what extent was their liability limited? They did not say they are limited totally, no. They said they are limited to the extent of £10. I can only pay you £10. If you like, bring a claim for £1 billion. I will only pay you £10. My liabilities are limited to £10. And then the plaintiff brought a claim for £24. But what actually happened? So if you are in University of Lagos, or if you are in any university in Nigeria, I'm very sure you have a library, right? So imagine that you were going to your library, and then you have books and all that, so many things, food, all that in your bag. You can't take it into the library. So where do you go to? You go to the cloak room, right? So they got to the cloak room, and then you paid for your properties to be kept there, right? Now, in the ticket that was given to you, right, in that ticket, there's after the front has your the bag will be held from the so time to the so time, everything. But then there is a C back at the front of the ticket. So at the back are now the terms. Don't forget that in my last class, let me see if I can get my marker, please. Help me pass the marker. Peace. Thank you, peace. So yes, as I was saying in my last class, so this is how it is. You have the things here, and then he says see back, right? So at the back, so let's say this is the back of the paper. It now has term 1, term 2, term 3, term 4, but then term 5 at the back now says that the company will not be liable for any package exceeding $10. You know that other things here have been stated as terms, but because we are not looking at those things, it wasn't even an issue in court. It was this one. Don't forget that it is a ticket, right? After he had paid his $2, they gave him what? Tickets. Abi, and then he carried his ticket. But in the ticket, after it contained the name, the this, the amount, the duration for which it now contains also C back, right? And then he looked at, I don't know, it wasn't an issue whether or not he looked at the back, right? As at now, we'll discuss that in the judgment. But the question is, can this exclusion clause bind him so much so that his lost bag, he cannot collect the £24 to which the goods and everything in it, the amount for the goods and everything in it, can the company say, no, we do not know anything about that, and then just take their own liability, exclude their liability and give him £10? That's the question that we're asking in court, for this case. Now, the court had to construe the effect of the exemption clause in the ticket. After the case was decided in the plaintiff's favor, the defendant appealed. The Court of Appeal used the occasion to lay down the guidelines for determining liability in the case of unsigned documents. So this is what they call a locus classicus. When you hear locus classicus, that means that this is the case classicus. This is the case that propounded the principle to which we are going to apply in this area of law. Parker versus Southeastern Railway. The Court of Appeal propounded the principle through which we will then apply the rules regarding exclusion clauses under unsigned documents. What is the name of the case? Parker versus Southeastern Railway Company. Do you understand that? Now, what were the three rules? There were three rules. The first one, if the person receiving the ticket did not see or know that there was anything or that there was any writing on the ticket, he is not bound by the condition. The court said that when you are receiving the ticket, if the person receiving the ticket does not see that there was a writing on the ticket or know that they were writing on the ticket, he would not be bound at all. Do you understand? So let us say that you went to buy something, and what are they supposed to give you when you go to buy something? Receipt. What are they supposed to give you? It's not receipt. Do you need to start reading the back of the receipt again? I want to buy something, you go to this thing, they give you receipt, bam, you look at it, receipt, you carry it. As far as he has the amount, right? You carry it and you started going. That's why he said, if the person receiving the ticket does not know or see that there was any writing on the ticket, he is not what? He is not bound. Then number 2, if he knew that there was writing on the ticket and knew or believed that the writing contained condition, then he will be bound. Now, you see, for this second rule, there are 2 legs. Number 1, if he knew that there was writing, let us put it like this. Number 1, this rule number 1, writing, if he didn't know that there was writing, right, then he is not bound. Equals to he is not bound. If he did not know that there was writing, then he is not bound, right? Number 2, if he knew that they were writing and he knew that those writing contained conditions, then is equals to bound. Do you see this? So there's a plus here. If he knew there was writing and if he knew that the writing contained condition, that is when he will be bound. If he knew that there was writing but he did not know that it contains condition, that is, then he will not be bound. Can you see that? So for you, this one, the first rule, when you are in exam, so that the reason why I'm abbreviating is so that you will remember, WB. So if he doesn't know that there is writing, then he will not be bound. Number 2, if he knew that there is writing and he knew that there is condition, that is when he will be bound. Right? What's our case? Parker versus South Eastern Railway Company, right? Parker versus South Eastern Railway Company. These are the principles laid down. What is the third one? The third one, if he knew that there was writing on the ticket but did not know or believe that they were containing condition, nevertheless, he will be bound if the party delivering the ticket to him does all that is reasonably sufficient to give him notice. So this is number 3. Number 3 now. They made 3 rules, but out of those 3 rules, we are calling 4 rules. So if he knew that there was writing but did not know that there were conditions, he will not be bound, right? But if he knew, number 4, if he knew that there was writing, he did not know that there was condition, right? But now look at it, there's an additional one. But the owner did everything reasonably necessary to let him know that there are conditions. Whether or not he read the conditions, the moment the other party has done what is reasonably necessary to let him know that there are conditions on that ticket, that is when he will be bound. So reasonably necessary, then bound. Are you seeing that? If he didn't know that there was writing, this one, he didn't know that there was writing on that ticket. What he thought he was collecting was just tickets or receipts. So he doesn't even know that there are writings around the receipt, excluding your amount, your name, your good, she gets. So if he did not know that there's writing, he will not be bound. If he knew that there was writing and he knew that there were conditions, he ought to have read it, therefore he will be bound. But if he knew that there were writings, but he did not know that the writings amounted to conditions, like those in the writing, there are conditions, he will not be bound. But if he knew that there was writing, he did not know that they amounted to conditions, but the other party did everything that was reasonably necessary. Are you listening to me? The other party did everything that was reasonably necessary to let him know that thing that you are carrying has conditions. Whether he read it or not is not necessary. So what you are supposed to prove here, you have to prove that they were writing and he knew that they were writing. You have to prove that the condition is stated there. You don't need to prove that he read the conditions. But what you have to prove is that you did everything reasonably necessary to know that the conditions were there, for him to know that the conditions were there. So those are the things that you have to prove for him to be bound, for him to be bound by the exclusion clause, and therefore you will not be liable for anything. Do you see it? These 4 things. Where do we find it? The case of Parker versus South Eastern Railway Company. company. Do you understand that? Now, let's move on. Now, the court then went on to state that whether or not a person who knows that there is writing on the document but does not know that it contains condition would be bound by an exception clause in the document depends very much on the type of contract and document. Now, I need you to then look at another thing that the court is trying to say, because this is another rule that we need to look at. Let me read it again. The court then went on to state that whether or not a person who knows that there is writing on the document but does not know that it contains a condition would be bound. That is this is the rule that we're talking about. When a person knows that there is writing but does not know that there's condition, is that not what the court is saying? But that does not know that it contains condition will be bound, will now depend. Number 3, the general rule is that he's not supposed to be bound because he didn't know that there were conditions. But then we also have to look at what type of document are we talking about? What type of document? Do you understand? Now, let's continue with what the court is saying. Thus, in receipt issued to a motorist at a toll gate, in receipt issued to a motorist at a toll gate could be reasonably be assumed. Okay, I think it's if receipt issued to a motorist at a toll gate could reasonably be assumed by the motorist to contain nothing more than evidence of payment, right? He would therefore not normally be bound by an exception clause contained in it. On the other hand, conditions contained in a bill of lading issued to a shipper of goods would bound him whether he reads it or not, or whether he is aware that the document contains conditions or not. Now, this is what we are saying here. We are saying that for this number 3, he doesn't just apply automatically, right? We are saying that there are 2 types of document that we are going to look at. If it is something like a receipt, for example, in a receipt you do not expect that you are going to find conditions at the back of a receipt. Therefore, if there were writings but he did not know that those writings contain conditions, then we also have to look at the type of document it is before we can say B this, that's mark, or B wrong. So if we are looking at writing, look at it. The rule is, if it is a writing, that is the document, there are writings on it, but that party, the other party, let me let you know, this is the let's say storekeeper who is saying that we have 10, we are only going to pay $10 for anybody, or £10 for anybody who has a problem, and this is B. So it is B that we are looking at here. If, okay, don't let me use B because I'm using it here. So let me just say this is Z. So if Z saw the ticket that was given and knows that there is writing on the ticket but does not know that there are conditions, whether it will be bound. Normally it's not supposed to be bound, but the court now went extra mile to say whether it will be bound will now be dependent on what type of document it is. If it is a receipt where you don't expect to find conditions, you can find writing in the receipt but you don't expect to find conditions, then he would not be bound, except he then goes further to do this reasonable, what is reasonably necessary to continue to show him. But if it is something like a bill of lading, or any contractual document which you know in this course of business the conditions are usually written in the bill of lading, or in the this, or in the that, do you get? Now, okay, for example, let me just give you an example. It might not be, let's say you want to buy a fridge, yeah, you want to buy a fridge, and then they gave you the specs of the fridge, a document that talk about the specs of the fridge, and that document that has an exclusion clause, right? Will you treat that document the same way you would treat a receipt? Like if you had bought the fridge, they now gave you a receipt. No, because before you bought that fridge, that document is said to contain conditions relating to the fridge. You ought to have read those conditions, and also it is taken that you have the knowledge of the exclusion clause in that document. That is different from when you go to the market and you went to buy something and they gave you receipt. Do you look at receipt when they give you receipt? Does anybody ever look at receipt to know whether or not there is an exclusion clause there? No. So if it was a receipt that was given, you will now be what? BX. Except the person giving you the receipt or the ticket then gives reasonably necessary. It does what is reasonably necessary to bring your attention to the fact that that receipt that I gave to you, that ticket that I gave to you, which ordinarily would, if you did not know there were conditions, would mean that you are not bound. Now I am beginning to bring your attention to it to make you bound. Do you understand? So that's why the receipt is what? BX, but the bill of lading is B at this level. Do you understand? Because you expect it to have the conditions. So let's continue with what the court was what the court saying. So the court then went, I'm trying to recap, the court then went to state that the whether or not a person who knows that there is writing on a document but does not know that it contains condition will be bound by an exemption clause in the document depends very much on the types of contract and the document. Thus, in receipt issued to a motorist at a toll gate could be reasonably assumed by the motorist to contain nothing more than evidence of his payment. He would therefore not normally be bound by the exemption clause contained in it. On the other hand, conditions contained in a bill of lading issued to a shipper of goods would bind him whether or not he reads it or whether or not he's aware of the conditions. Now, the reason why a person receiving the bill of lading, that is this, the reason why a person receiving the bill of lading will be bound seem to me to be that the great majority of cases, persons shipping goods persons shipping goods do know that the bill of lading contains the contract of carriage, and the ship owner or the master delivering the bill of lading is entitled to assume that the person shipping the goods has the knowledge. Do you understand? This bill of lading is a contractual document. You know what a bill of lading is now? You want to ship your goods from one place to the other. Do you understand? The bill of lading is the contractual document of everything relating to how your goods will be shipped. So it is assumed that you are supposed to know this thing. It's just like you want to, for example, you want to go for a training. Do you understand? A training, let's say a theater training, and they tell you that for the 3 months of you being in this training, this is the document they give you. The document is there, everything that you need to know. And they told you that during the time that you'll be training here, if you get injured, if you do this, we are not going to be. It is there. It is believed that if they tell you everything that you need to know about your training is in this document, you should have read the document. So if you knew that they were writing there, but you did not necessarily know that those writing contains condition that contains the exclusion clause. Do you understand? But it now depends on the type of document. If the type of document is such that you do not ordinarily expect to find conditions, that's the rule. You know, if it's such that you do not ordinarily expect to find conditions, for example, receipt, you would not be bound. But if it is such that you expect to find conditions, whether or not he has done what is reasonably necessary is not necessary, you will be bound regardless. So if it's such that you don't expect to find conditions, you will not be bound, right? But if, that's when we will now go to number 4, if it takes reasonable steps to let you know that conditions are there, then you'll be bound. Can you see how the 4 rules operates? Do you understand? Any following? Sorry, peace. Do you understand? Okay, good. Now let me just do a recap again. Now we are saying that we have, if there is a document, right, and there is writing, you did not even know that there is writing on the ticket, on the receipts, on whatever you were given, you will not be bound. This one, you didn't know there was writing, you will not be bound. Now, if you knew there was writing, I knew that it contained conditions, you will be bound. Now, see, if you knew there was writing, but you did not know it contains conditions, naturally, you should not be bound. But then, it now depends on the document. You would not be bound if it's such a document that you don't expect to find conditions. However, you will be bound if it is a document that you expect to find conditions. Now, if it's not a document that you expect to find conditions, then you now go to the 4th one. You would only be bound if the other party has taken reasonable steps to let you know that the document contains conditions, which will make you bound. Do you understand? What is the case? Parker versus South Eastern Railway company. Now, let's go to our own Nigerian case of Odeniyi versus Zad. Odeniyi versus Zad. This is supposed to be a very interesting case. Now, the plaintiff was a registered contractor with the Western States Ministry of Agriculture and Natural Resources. Following the urgent order for quantity of wire netting from the ministry to be delivered not later than August 9, 1968, the plaintiff went to the defendant's shop. The plaintiff went to the defendant's shop. Sorry, just give me a minute. Yes, the plaintiff went to the defendant's shop on August 2nd, 1968, bought and paid for the goods and issued a receipt and a delivery note for the goods. It was established before the court that the plaintiff had informed the defendant of the essence of the delivery and of the essence of the delivery on August 2nd. That is the date of purchase. The defendant never delivered the goods. Consequently, the plaintiff lost the contract with the ministry and sued the defendant for the loss. So what are we talking about here? The ministry said that they wanted certain things and said they wanted it on August 9. Very importantly, okay, no problem. You want certain goods, you want it on August 9, no problem. On August the 2nd, they went to meet the sellers, and then they told the sellers, I need so and so goods. I need it before August 9th, right? It's very important to me, and I need it. And they let them know why they need it before the date that they need and all that. And at the end of the day, the plaintiffs, I think it's the plaintiffs. No, it's the defendant. The defendant did not deliver the goods, and then the plaintiffs who were supposed to get the contract from the ministry couldn't get the contract because they did not have the goods which they were supposed to have. So they sued the defendant for the loss. Now, the defendant contended that they had discovered an error in the selling price of the goods and payment had been made by the plaintiff. They were entitled to withhold delivery and to ask the plaintiff to elect between receiving back the money or renegotiating for the purchase of the goods at the correct price. They also contended that the letters E and OE, meaning errors and omission accepted, printed on the receipt issued to the plaintiff was sufficient notice that the goods were sold subject to conditions. Now let's understand what that means. So the defendants are saying that, well, after the plaintiff left on August 2nd, maybe they were such in a hurry that they did not get so many things down, but some of the things that they got down, they mistook the prices for those things, and told the plaintiff that it was so price when in fact it was higher, right? So they had to talk to the plaintiff. I think you should know that as at 1968 there was no phone, so it wasn't something that you just, before the person gets to his house, you just carry your phone. Hello, what we said now is not the case, so blah blah blah. Sure, you get. So now you have to start writing letter, sending letter, postal office, all those kind of things now to get across to the plaintiff. So before they could do that, August 9th had gone. So they wanted to give the plaintiff the opportunity to either ask for their money back, they'll give you your money, or you pay. You will do another contract where you renegotiate and then you pay for what we're about to deliver to you. But we cannot just deliver the goods to you like that, because then we will be the one losing, right? So now that was what they were saying, and then they said that in the ticket, it was contended that the letters E and OE printed on the receipts. Now look at it here. Where did they come to? On the receipts, they said there was what printed? E and OE, right? And that means error and omissions exempted. Error and omissions exempted. Now, according to them, this is supposed to mean that we will not be liable where there are errors or omissions in our contract. So we are excluding liability to the extent of errors and omission. That's what they are saying. And then, you at the other party, you are saying, what is all this? The defendant is saying that in the receipt that we gave to you, there is E and OE. What is our rule? Come here. Where there are writings on the receipts, and the writings contains condition, Naturally, the defendant is not supposed to be bound, but this will only operate when we know the kind of document. If it is such that it is a receipt, a document rather, if it's a document that you don't expect to find conditions, for example, receipt, then you come down here, they must take reasonable steps to let the other party know that that condition exists, right? But if it's such as to contain, then it will be bound automatically, right? So we then come here. So the next question that every reasonable person should ask is, did you take reasonable step to let that party know, because of the nature of the document being such that you don't expect to have conditions in them? Did you take reasonable step to let the other party know that the document contain receipt? Do you understand? Now, what did Johnson J say? Johnson J held that the plaintiff was not bound by the condition. In the first place, the existence of the so-called condition has not been brought to the plaintiff's notice. Why did the court say that? It has not been brought to the plaintiff's notice because it is a document that naturally should not contain condition. And if that is the case, then you are supposed to bring it to the plaintiff's notice by what is reasonably necessary to bring it to the plaintiff's notice. A person who is issued a receipt for the payment of money could not be reasonably expected to look for any conditions in it. Something more has to be done by a person relying on any condition in the ticket or receipt to put the other person on notice. This has not been done in this case rather. Furthermore, even assuming that the plaintiff has seen the letters E and OE, so we are saying that, okay, let us come back to this part. Their writings and their conditions, and the plaintiff knew that there was writing and knew that there was E and OE. So he is coming back here. So he's saying that, furthermore, assuming that the plaintiff has seen the letters E and OE, he could still not have been bound because the meaning attributed to the letters by the defendants were particularly within their own knowledge. That is, that the letters were capable of other meanings beside these ones. The court will not resolve any obscurity or ambiguous term in favor of the defaulting party. Now, this is what the court is saying. Let us even say that we are not going in this rule that says where there's writing but he did not know that there were conditions. Let us come to this one where there's writing and he in fact did know there were conditions. That condition, E and OE, is subject to so much interpretation. Why you write E and OE? I can interpret E and OE to mean anything. It is such that the meaning is only within that of the defendant, is within the knowledge of the defendant. So something like that, you are supposed to bring it to the attention that E and OE means, or you should have written it in brackets. And this is an assumption that we are making, that he in fact even read the condition. In this case, he did not, because it is merely a receipt you don't expect. Do you understand? So let us even say that he did. He will still not be bound. Do you understand? He will still not be bound. There is something known as the contra preferitem rule. Where there are ambiguous terms in a contract, it is resolved in favor of the other party, not is resolved in favor of the party that drafted the contract. So in this case, there are ambiguous terms. So it's resolved against the party who drafted the contract. So, but that is even assuming, in this case, there was no evidence that he knew that there were conditions. So you can see that when you are reading through exam and then you see question on unsigned, first ask yourself, did he know that they were writing? Okay, he knew. You cancel this one because he knew. You cancel it. Okay, did you know they were writing? Yes. Did you know there were conditions? No, he did not know. Cancel this one because if he knew there were conditions, they will be bound, right? So you cancel this one. Did he know that they were writing? Yes. Did he know there were conditions? No, he did not know. Okay. If he did not know, what kind of document is it? You have to come here. What kind of document is it? Is it such that he's supposed to know or such that he's not supposed to know? Now, such that it's supposed to contain condition or such that it's not supposed to contain condition. Oh, it's such that it's not supposed to contain condition. Then, if it's this, then has he taken reasonable steps? If he has taken reasonable step, then hey. But if he has not taken reasonable step, then no. Do you understand? So, can you see how it works? So, let's continue with the notes so that we can finish our class for today. How many cases do we are almost done. That's very good. Yes. So thus, for the innocent or injured party to be bound by the exemption clause contained in a document not signed by him, the document must be a contractual document. This is what I'm talking about. So if you are saying that an innocent party to be bound by the exemption clause contained in the document, it has to be what? Something that is of a contractual nature. Now I'm going to explain this very soon. Now it must be admitted by the court as a document containing the whole contract or some terms of the contract. As we have seen, by their very general nature, receipt and ticket are not contractual documents, because their very nature, they merely acknowledge the payment of money and act as a pass for the enjoyment of a service. Any party wishing to rely on exemption clause in such a document has to take steps to bring it into the notice of the other party. Now, the reason why we have this rule, this reasonably necessary steps to bring the condition to the other party. Why? Because of this. You know that, I don't want to, here's congested. We have A, we have B, right? So let us say A is the park man, right? And then B went to park his car there and all that. Now, you know that there is offer, there is acceptance, there is consideration. The reason is offer, acceptance, consideration must have moved. The contract has been concluded. Then you now issue receipts. Don't forget that as at the time we were making the contract, there were terms that we were accepting and all that. So the contract has been concluded. Then you now brought the receipts. After we've done everything, this is where we concluded the contract. After the contract has been concluded, you now bought a receipt that now contain a condition, and you want that condition to operate in relation to the contract? No. Now, do you see why it's, and then the worst part is you didn't even let me know that receipt that you are giving me contains conditions. Do you understand? It's going to be unfair. You get? So that is the reason why the court will say that if you are going to put conditions in receipt, you must take necessary steps to let the other party know that receipt contains conditions. So let us look at Chapelton versus Barry, another very important case for this principle. Chapelton and Barry, the plaintiff wished to hire 2 deck chairs from the defendant counsel. Near the pile of chairs, there was a notice stating that each chair was available for hire at $2 per session for 3 hours. So he entered into the place and he wanted to hire a chair. And then there are stacks. So beside the stacks, it was stated there, everywhere was written on the wall, that each chair is available for hire at $2 per session for 3 hours. So it was clearly written here. You can see the price, you can see the terms, right? Very good. Now, the plaintiff took 2 chairs and obtained a ticket from the attendant, which he put in his pocket without reading, as I would have done if I go to a supermarket and I went to buy goods at the supermarket, and you pay and they issue receipt to you. Do you begin to analyze the receipt? Do you understand? So as I would have done, do you get? Just put it in the pocket. Now, the chair he was sitting on collapsed and he was injured. In reply to his suit for damages against them, the defendant denied any liability, pointing out that there was a provision at the back of the ticket excluding them from any liability for any injury or damage arising from the hire of the chair. It was held that no reasonable person would imagine that the ticket was anything but a receipt for the money paid for the chairs. The notice on the beach constituted the offer, which was accepted by the plaintiff when he took the chairs. The ticket was therefore issued after the conclusion of the contract. It was not a contractual document. Can you see? It was not a contractual document because there was already offer. When he entered, he saw the offer there. This thing is going to be going for this thing. He paid, and then you can see that at the point of payment, there has been offer and acceptance, right? And then by the time you take your chair, the contract was already concluded. Then you gave him receipts. So we look at it. Did he know that there was writing on the receipt? Yes. Did he know that there was writing but it contained condition? No. So if this is the case, then we have to look at what type of document. If it is receipt, then no, except it is brought to his attention, which it wasn't. So you already know that it is not going to apply. So we look at the next case of Thornton, Thorton versus Shoe Lane. Thornton, Thorton versus Thorton versus Shoe Lane Parking. A case concerning an automatic car park, where it was held that an exclusion clause contained in a ticket machine was not effective because after the fact that there was no reasonable, because apart from the fact that there was no reasonable person could expect the ticket to contain more than an acknowledgement of payment. The ticket itself was issued after the conclusion of the contract, and it was therefore not a contractual document. Lord Denning was particularly struck by the fact that once money is put into the machine and the ticket comes out, the customer cannot get the money back even if he does not accept the condition on the ticket. Now, this case is also very, very important. Now, I've told you two things. I've showed you two signs. Now, one of the things I told you is this rule, right? This rule, I applied it from the case of what Parker and they were the ones who propounded it. And then the second part was the Nigerian case of Denning versus Zad. That is perspective in relation to this rule. Now, the second perspective that I gave you is the contractual document rule. Because at the end of a contract, anything that comes after offer, acceptance, consideration, everything has been concluded. At the conclusion of a contract, everything that comes after it cannot be said to be a contractual document. So therefore, when we are looking at the document, when we say receipt, the question is it a contractual document? So for this rule number 3 to apply, you have to come down. What type of document is it? Is it a contractual document that was part of the negotiation? Because if it is, then it will be assumed that he has the notice, and then he will be bound, right? But if it isn't a contractual document, for example, in Thornton versus Shoelace, it was a car of automatic car park. So the way there is no person standing there, you know the way car parks are now, that you're going to have a box here, then you have a line, then cars will come here. So this box usually has a person staying here. In this case, there was no person, it was a machine. So the moment you drive your car to this place, you will come down, go and meet the machine, pay your money, and then the machine automatically gives you a ticket. And then the moment it gives you a ticket, it opens automatically because you've paid. It opens, so it's an automatic car park. It opens automatically, and then you can drive in. So you can see that there's no person here, right? So it was after he had paid, and then he was given the ticket, that he had that exclusion clause at the back. Then Lord Denning was saying that, okay, imagine that he got the ticket and then he saw the exclusion clause at the back and he does not like the exclusion clause. Can he return the money and say he's no longer interested? No, the contract had already been concluded. It's a machine. You want to break the machine's head? Do you understand? So it shows that it was after the contract. Let us juxtapose this with when you're about to pay, the machine shows you this and this and this and this, the terms, the exclusion clause that you saw at the back of the ticket, the machine showed you before you paid. Can't you see that that's part of the contract? It was said before the conclusion of the contract, therefore it formed part of the contract. But this was said after the contract has been done, then, and you did not let it short. You didn't even bring it to the part when the contract has been done. You then have to show reasonable steps that you brought it to the attention of the other party. In this case, it was a machine. Is it machine that want to be bringing it to the attention of the other party after the contract has been done? Do you get? So I don't want you to get confused here. This rule only applies when we look at the document. If the document is such that it is not a contractual document, then you must then come to this rule. Was there a reasonable step to alert the other party of the condition in the book? But if it was such that it was a contractual document, then you don't need this rule. Simple and short. Do you understand that? Now, by contrast, terms and conditions contained in a document generally known to contain such term will be held binding. The example of bill of lading was given by the English court in Parker versus South Eastern Railway. Another document of that character is way bill. And then we'll be talking about that way bill in my next class, because now we are done with the part 1. Then the way bill, I told you that when that document is a contractual document, a document that you naturally expect to find conditions in it because it was given to you, notice was given to you particularly before the end of the contract or something, then you can say that you don't need to bring necessary reasonable notice to the other party because it is a contractual document. But if it is not a contractual document and it was given to you at the end and all that, then you have to bring reasonable notice to the other party. So with that, we end our class for the part 1 of this session. In our part 2 of this session, we'll look at way bills. We'll look at Iwoha versus this. Is something wrong? We'll look at Iwoha versus Nigerian Railway Company. We're talking about way bill. We'll look at Kano Air versus Staffa. We would also look at Imo Concord Hotel versus Anya OK versus, there are so many cases, and in fact we'll also look at things from the perspective of an illiterate, where an illiterate is the one who is being what is it called, who has been given the book and all that. Does the court have a higher threshold when it comes to that of an illiterate? There's something, in this case we did not envisage that of an illiterate. So what if it's an illiterate? Is there another condition for us to attach to the rules regarding unsigned documents and stuff like that? And that is what I will be discussing in my next class. Thank you so much for watching to the end of my lecture. I will see you in my next class. Thank you.